Make declaration. My lord, I beg to mention item number 6, madam. 6, my lord, hearing matter, my lord, that I pray with your lordship, that may be taken as a first item, first hearing matter.
You want to upgrade it?
My lord,
Okay, that can be accommodated. Let us see.
my lord,
Yes.
Make this a workshop. I beg to mention item number 5. I have taken the concept of the other side. In this case, the parties have taken initiative to compromise the matter, my lord.
That's still 2016 matter, we are not adjourning. Let us call the matter. It's a 2016 matter. In the hearing list, we're not adjourning. Matter still item 12. Yes.
My lord, I pray for listing of an urgent matter, that is civil revision petition.
Give the request to the court master.
Hi, lord.
May I please your lordship? I beg to mention item number 4. I'm appearing on the
2012 matters are not being adjourned.
Your Honor, the learned junior counsel assisting the Anandam is facing a certain medical emergency due to which
2012 we are not adjourning the matter.
Lord, in this matter, I am for the appeal amendment. I will be allowed to check the record. Okay.
May I please proceed? I beg to mention item 14. I paid adjournment for today due to illegal of my senior. Kindly matter may be fixed on 22 or 26 of this month.
You're taking consent of the other side?
Yes, I am.
Okay. Both sides are presented on the prayer made by Lone Counsel to the opponent. The matter stands adjourned today. This one, do a date after vacation. Do date after vacation.
Okay. And record matter, I begin item number 17, no? 17, right?
For motion, supplementary item 16.
Make it second call.
CRP item, supply item 16.
Second call.
Daily list, item 2
One.
for orders.
What's your office? Okay.
Please, your lordship, my senior counsel is on the way. I will come back. Can you pass over the case?
Okay. Return of services awaited. List on. Do this after a week.
Okay.
Little high 17. 17, 18, 19. Yes, item 17. Okay. No, it is on call for the appellant. how the respondent is presented. Matter is ready as regards service and the TCRs have been received. Accordingly, this is the matter for hearing on. During the week commencing 20 of a year there. 20 July 2027. The appellant is there. Huh? Appellant is represented. Both sides are represented. Okay. Here's item 18.
Wait, please, my lord. My lord, respondents are otherwise appearing in the matter they are represented. Respondents are otherwise represented in the matter. The TCR perhaps has not been received.
TCR is not received. Okay. Mr. Incharge, the counsel for the appellant is present. None appears for the respondents. The registry shall send a reminder for the TCRs to email to the respective courts. Next, list transference for everything, receipt of TCRs. Due date after vacation for TCR. Yes, item 19.
Please look at.
Give a date. Just wait, the records are not here. We're finding out the records.
For hearing under order 41, rule 2. Item 1, RSA 59/26.
Wait, please, my lord.
Yes.
My
Yes,
lord,
Mr.
in
Chair.
this case, my case depends upon the DWs, my lord.
DW.
The certified copy of DWs I have applied for, my lord, but did not receive till date, my lord. It will be taken after 1 week, my lord. Next week, any day, my lord.
The prayer made by Mr. Ramesh Sheth and counsel for the appellant. List on 17/6/2026. 17/6.
76, not obliged.
Time being item 19, CRPIO 28/2026.
This case service is complete, lordship. Name of the council respondent is shown in the course list. Was listed on yesterday also.
Okay, heard Mr. S.T. Prakash sir on counsel for the appellant, none appears on call for the respondents. Next, the matter was earlier listed on 3/6/2026. Mr. Hava is the learned counsel for the respondents were absent from the matter was adjourned. Even on call the, not required. Next problem. By filing this this application under Article 227 of the Constitution of India, the petitioner has assailed, petitioners have assailed the order dated 20/12/2025 passed by the learned additional district judge Kachhar in TA number 2 of 2023. So by the said order, apart from 7 issues already framed by the learned trial court, the first appellate court had framed as many as 17 additional issues. And permitted the applicants to take steps. Next paragraph.
Forty-one.
Where is that petition?
166, Lordship.
Where is that petition?
Petition filed by the appellants, page 166. Lordship.
6.
That copy.
Next one, the respondent says the appellants in T8-2 of 2023 had filed a petition under order 41 rule 25 CBC read with section 151 order 41 rule 25 read with section 151 and section 107 CPC.
Hello. 43.
Yes.
And for SPN 127. And my submission is that actually affidavit of business ready, but party could not come to till only 2 weeks time, maybe in the meantime I shall file.
No, it's not even required. It's only a question of law, order 41 rule 25. What will the parties communicate to you? A simple application under order 41 rule 25 was allowed. Is it permissible?
I would like to file affidavit. Affidavit is ready only 2 weeks time, maybe then I shall file immediately.
How will the affidavit change anything? It's a question of law. Order 41 rule 25 by an affidavit, can you make it, can you improve what has been before the trial court?
Actually, trial court decided 7 issues, appellate, trial court framed 7 number of issues.
So without arriving at a decision, how the appellate court framed 17 additional issues?
They have filed objection in the appellate court.
Tell us the law. How in the appellate court, the appellate court will arrive at a decision that the judgment could not have been delivered on the basis of 7 issues. In a suit, can there be 17 plus 7, 24 issues?
Those 17 issues issued framed by appellate court, that is not similar to 7 issues already framed.
That's what I am saying. 17 plus 7, 24.
Yes.
24 issues. It is very. This was the first time I have seen any case where there are 24 issues. I don't have an experience of having 24 issues dealt with. Please tell what is the stage when the appellate court can take into consideration whether the issues are there or not.
Well, it is given to WS and plain filed by the trial court, but today I am not here. Lordship may fix any other date. In the meantime, I shall file the affidavit. Only 2 weeks time maybe. In the meantime, I shall, as well as possible, I shall.
No affidavit business. From take it out and talk to the respondent, the appeared and chief for town. Use the code. Use the law. Use law. Okay, now 22, 26. Make clear that matter would not be adjourned on the next date of listing.
There is no stay in the appeal, Lord. There is no stay in the appeal.
The order dated direction is given to take steps so the next date. That is page 180 of the revision petition. Last page, bottom part.
Okay, next para. The learned counsel for the appellant has raised the prayer for interim relief. So consideration on a consideration of the nature of the order that is passed by the interim order that has been passed by the trial court and then first appellate court, the further proceedings of TA number 2 of 2023 pending before the learned additional district judge SR Silchar shall remain stayed till the next date of the stay. Next paragraph, the appellant, the petitioners have produced a certified copy of the order for the learned first appellate court.
Deeply open.
This conference.
22.
Service court, thank you very much.
For hearing item 3.
May I please, Your Worship? I am the plaintiff appellant. This is a concurrent finding. The appellant has lost in both the case court, hence this appeal. The fact of the case is that predecessor in interest of defendant number 1 to 6 and predecessor of interest of original plaintiff number 3 to 7 purchased the suit land from Shivnath Sharma by enjoying possession over it. They obtained mutation order dated 6/6/33 and correction was made in the revenue record on 28/34. PP number was 33, DUG number 33, area of land 1 kata 2 lesser. And the present appellant and the respondent are the legal heir of predecessor of interest.
You are the defendants.
I am the plaintiff and appellant.
You are the plaintiff appellant. Okay.
A predecessor of interest of original plaintiff number 3 to 7.
That's my question. Plaintiff numbers 3 to 7.
Yes, Your Lordship.
Yes.
Actually, may I please, Your Lordship, lower court did not go into the depth on the basis of the pleading, document, and evidence, and the appellate court has not exercised its power as provided under Order 41, Rule 31 of CPC, and has not passed the region order, and has simply upheld the judgment of the trial court. Your Lordship, may I read the plain? May I please, Your Lord, kindly peruse the title judgment of page number 9. This appeal being preferred against the judgment and decree passed by Lioness Civil Judge Senior Division Lakhimpur, not Lakhimpur, in title suit number 10 of 2002 and coming on for final hearing on 16th day of May 2008 in presence of so and so. This appeal has been preferred against the judgment and decree dated 6/9/2005 passed by Lioness Civil Judge Senior Division Lakhimpur, not Lakhimpur, in title suit
You
number
see,
10 of
We have
2000.
an initial difficulty in understanding your, the relationship. Number one, in your plaint, you say that the original owners were Sultan Sheikh and Multan Sheikh.
Yes, Your Lordship.
Then you say that late Badal Hussain was your grandfather.
Yes,
And then you say that he has 4 sons and this is how it devolved.
yes.
How did the original land pass on to you? You have not said. You have just merely said that there was a deed of partition. The title of Badal Sheikh, you're not Badal Hussain. You have not been able to understand.
Badal Hussain is the grandfather of plaintiff.
No, we understand, but how he has the title? You say that there was a partition between.
Yes, Your Lordship. Partition deed was,
We understand, but for partition there must be some title, some semblance of title. How did the title devolve?
actually, it is a partition case in 1961.
No, see,
But
there's no difficulty in understanding that. What I'm trying to say, that there were 2 parties in the plaint. First was this Sultan Sheikh and Multan Sheikh. The other party in in your plaint is late Badal Hussain. You say that there was a partition between them, deed of partition. Now, deed of partition, how is it, how you're showing that they had title and therefore there was a partition? I could not.
in the trace map also,
No. Please try to understand. Having read this and where there was a mental block, I could not proceed further. So you have to first help me to overcome, to understand the facts of the case. How did you derived title through that partition? Then you say that this partition gave you the title. Now, please explain to me how this title devolved. Title must lawfully devolve. You see, I have no business with A. And then suddenly I have a deed of partition with A for in respect of a land. Is it permissible? If I have a title, then I can understand there can be a partition deed. So your genesis of the title I have not been able to understand. So first, please help me overcome that barrier.
Your Lordship, it is not a partition case. It is only in the year 2002 when the fire broke and defendant encroached upon the land for which the plaintiff prayed for demarcation of the suit, which was refused by defendant, so the suit was filed.
Okay. Okay. Please proceed.
Paragraph number 2. The appellant were the plaintiff and the respondent were the defendant in the above said suit. It is pertinent to mention here that plaintiff number 1 and 2, namely Muhammad Idris Ali and Muhammad Aftab Alam, have not preferred appeal against the impugned judgment. The plaintiff filed a suit for declaration of the right title interest over the suit land and also for partition and injunction. The case of the plaintiff in brief is that one deceased Badal Hussain had four sons, namely Abdul Hajiz, Muhammad Khalil, Sultan Sheikh, and Multan Sheikh. The suit land, which is described in the schedule of the plaintiff, was purchased by Sultan Sheikh and Multan Sheikh, son of late Badal Hussain, from one Sibnas Sharma. Possession was also delivered to them, and their name are mutated on the suit land by mutation order dated 6/6/1933 for the area of land measuring 1 katha 2 lesser. Further, case of the plaintiff is that landed property of deceased Badal Hussain were amicably partitioned and settled by executing deed among the son of Badal Hussain. In accordance of the said deed, the descendant of the deceased Badal Hussain started possessing their respective share of the property. During subsequent settlement, the suit patta got resurveyed into the new patta number 52 and that number 53. It is further contended as per the agreement between the defendant among the four sons of late Badal Hussain, a sketch map was also prepared showing the respective share and possession of both the parties over the suit land, and since then, the plaintiff continued possession over the suit land by constructing so premises of their own share, which was let out to the tenant on rent. It is alleged that on 6/4/2002, the above said shop premises belonging to the plaintiff got fire due to short circuit of the electricity, and the shop premises were gutted in the fire. Taking advantage of the situation, the defendant number 1, 2, 3, and 4 encroached the some area of land of the plaintiff by making alteration of the boundaries line. That apart, defendant number 1 sold out his share of land on 4/11/93. As per agreement for partition dated 21/3/93, the plaintiff number 1 and 2 owned 1/4 of the share of the scheduled land. Plaintiff number 2 purchased 1/2 share of one scheduled land. Accordingly, the plaintiff number 3, 4, 5, 6, 7, and 8 become the sharer of the 1/4 of the total scheduled land, as per the agreement dated 21/3/93. After the descent, once the fire and the alleged encroachment by the descendant, the plaintiff through requested and demanded for proper demarcation of the boundary line. The defendant did not respond to their request and demand. The defendant rather started collecting rent from the shop premises. Pro forma defendant number 12, 3, and 14 are the son of defendant number 2, who let the shop premises in the rent to the defendant number 15. That apart, pro forma defendant number 10, also a tenant of defendant number 8. It is further stated that defendant number 8 and 9 purchased the share of land of defendant number 4. Defendant number 7 also purchased the share of defendant number 1. On the other hand, the defendant number 7 obtained let out of the share premises on rent of defendant number 11. Pro forma defendant number 19 was a tenant of plaintiff number 8. After the incident of the fire and disposition of the plaintiff by the defendant on 6/4/2002, the plaintiff have brought this suit for the relief as prayed in the plaint. Defendant number 1, 2, 5, 6, 7, 8, 9, 11, 12, 13, 14 contested the suit by filing written statements separately on the ground that there is no cause of action. The suit is barred by limitation, the suit is barred by estoppel, that the claim of the plaintiff is not tenable. The case of the defendant number 1, 2, 5, 6, 12, 13, and 14 is that suit land was purchased by their predecessors Sultan Sheikh and Multan Sheikh, who were the son of late Badal Hussain. The suit land was mutated in their name in place of Sibnas Sharma, the original owner. Thus, only Sultan Sheikh and Multan Sheikh become the owner of the suit land. Thus, the defendant number 1, 2, 3, and 4, being the son of Sultan Sheikh, become the owner of half of the suit land and continue their possession by right of inheritance of 2 lessers of land by each. Defendant number 1 subsequently sold out his share. In this way, the defendant continued their possession over their own respective of land and let out the shop premises on rent. Municipality holding number issued in the name of the defendants. In view of the permission granted by Bihupuria Town Committee, it is further stated by the defendant that 4/11/93, defendant number 7 and 11 purchased 456 square feet of land under Doc number 653, along with temporary shed without any objection either from the plaintiff or from any other corner. The defendant number 8 and 9 also purchased 250 square feet of land from the total two lesser under Doc number 653 from defendant number 4 by executing the registered deed on 2/2/98, and in this way he possessed the land, he possessed the said share. This defendant denied any family partition executed amongst them, and hence they prayed that those partition deeds are to be declared as illegal and void by filing their counterclaim. Defendant number 7 and 11 stated that defendant number 1 sold 456 square feet of land having temporary construction by sale deed of 4/11/93 under the Doc number 653 in favor of defendant number 8, and defendant number 8 was possessing the said share without any objection either from plaintiff or any other person. After purchase, defendant number 7 let out the shop premises on rent to defendant number 11. They alleged that plaintiff Idris Sheikh
I'll have difficulty in understanding it. I've told you, unless I know the flow of ownership, it's very difficult to understand. You see, what you say is that you, plaintiff number 1 and 2 are the owners of 1/4 share of the total land. Then you say that the defendant numbers 1 and 2 are also owners of half of the land purchased from one Tarsulla. Now, how this Tarsulla comes in between, we don't know. There's no narration of how the land devolves on Tarsulla, how from there you purchased. Then you say that defendant number 3, 4, 5, 6, 7, 8, they also are the owners of that 1/4 share of land. So you are making a distinction. You first say about plaintiff 1 and 2, and then you say plaintiff numbers 3 to 8. You create a distinction and for the purpose of bringing them the owners of 1/4 share. Then you say that the defendant plaintiff numbers 3 to 8, in addition to their becoming joint owners of 1/4 share on the strength of partition deed, plaintiff number is the shareholder of the land is the purchase from Matiur Rahman. So where does Matiur Rahman come in? We'll have to show the flow of the title, then we'll understand. This land is how many owners? How is the transfer of property being made? How the partition is being done? You refer to the partition. In the partition deed, you don't even know how they are devolved, how the ownership is devolved. You see, in a partition suit, the primary concern of the court must be that there should be that when a preliminary decree is issued, the court must declare the shares of each person. Now, how will I understand?
So it is not a partition case. It is only demarcated after gutted the fire.
No, you say that, you see, if it is not a partition, then you will explain to me. What you say is that there was a partition in 1993, and then there was a fire in 2002. After the fire was there, then the defendants took over excess share of their land, excess of the partition, and they occupied more land. And then you say that out of the more land, one of the defendants sold the land to another, to defendant number 7.
Moreover, your lordship.
So that means what you are claiming is a part of your share of the land. Your prayer is plaintiff numbers 1, 2, 3, 4, 5 have right and the interest in the respective 1/4 share. Can there be a declaration without a partition? But then under the specific relief act, it is hit. Then you say that the schedule land be measured through a commissioner and then shares be allocated and transferred. This is nothing but partition.
Your lordship, commissioner and Mandal.
Commissioner will come when we pass a preliminary degree. There's no prayer for that, those things. But still you omit that. Let us say that you have a share. You determine the share and give you the share of your land. After the commissioner makes the assessment of the land. That is nothing but a part of the preliminary decree. After a decree, we can't give it to the commissioner to make a partition. That is before that. Unless you show me that the thought process of the court is incorrect. And then you say that you not only give the partition, now you eject the others and give me the possession.
Your Lordship, kindly peruse the prior portion in plaint.
I have perused it. That is why I am saying it. When I am reading it, I am not looking through this, and I'm just refreshing my memory just to have that I am not wrong. I would not have said so much if I have not read it. Tell me if I am wrong in my appreciation. Just tell me that the court is wrong. I may be wrong because you see, I just flip through the papers and then form an opinion and jump to conclusions. I may be wrong, horribly wrong. But please tell me if I am wrong in the appreciation of whatever I have said till now. Mr. Barwa? Just the
Yes,
preliminary
yes,
fact,
that is,
because I must
that
understand.
that is the correct position, Lordship, what is narrated. Now the trial code hold that, not that there is no jurisdiction or nothing that says it. Trial code that they have not substantiated that they have claimed on basis of the ancestral body. But their document said that they could not prove that there is no deed is there, it is not ancestor. Their submission on basis of that statement. And the court.
No, I'm just trying
the
to
court-
understand. No, we'll allow Mr.
And
Mrs. Bhattacharjee to speak
court,
first.
Lordship, what court hold?
No, no, what
for
court
the,
has, Mr. Barwa,
Yes,
what court has held, we'll get it from her first.
Yes.
Because she is the appellant. I'm just trying to understand
yes,
how the property has devolved on the people.
Yes.
Is there anything on record?
yes.
There are materials on record to show how property is devolved.
Nothing is giving.
Nothing is there. Okay, now you please proceed.
The suit is barred by estoppel that the claim of the plaintiff is not tenable. The case of defendant number 1, 2, 5, 6, 12, 13, and 14 is that Suitland was purchased by the predecessor Sultan Sheikh and Multan Sheikh, who were the son of late Badal Hussain. The Suitland was mutated in the name in place of Sidnath Sharma, the original owner. Thus, only Sultan Sheikh and Multan Sheikh become the owner of the Suitland. Thus, the defendant number 1, 2, 3, and 4, being the son of Sultan Sheikh, become the owner of 1/2 share of the suit land and continued their possession by right of inheritance over 2 lessons of land by each. Defendant number 1 subsequently sold out his share. In this way, defendant continued their possession over the own respective of land and let out the shop premises on rent. Municipality holding number were issued in the name of the defendant. In view of the permission granted by Vihupuria Town Committee.
Just a moment, I'll just interrupt you again. The entire suit land is 5.5 acres. Is it? Or the land you are seeking is more than 5.5 acres. How much is the land which you claim to be in your share?
1 katha 2 lesser.
1 katha 2 acres. Something is not adding up. Please come to page 47. Page 47 is the schedule.
Yes,
In schedule, you say that in addition to partition of plaintiffs to plaintiff number 1 and 2's 1/4 share
yes,
and 3, 4, 5, 6, 7, 1/4 share in respect of 5.5 lacha. So therefore, this 8 people, 5.5 lacha is approximately 792 square feet. So 1/4 share will come to something 4 lachas, 4.2 lachas or something. Just an estimate without correct arithmetic. Now then you say, page 48, in respect of 5.5 lacha in dark number so and so, as per the deed of partition and sketch map dated so and 2.5 lachas, 36 square feet, and 4 lachas, 18. That is not adding up to what you are saying. And how will I find out? Let us assume that I will do that arithmetic. It takes me some time, but I will do that arithmetic. But in addition to partition of plaintiff's 1/4 share in 5.5 lachas, you where is the Jamabandi
Jamabandi
exhibit?
exhibit. Exhibit 1. Jamabandi name is there.
So the total land is 1 kata 2 lechas. The Jamavandi. Give it 1%. It is 1 kata 2 lecha. Then
Actually, your lordship, land has not been measured by Condor.
no, measurement will come only when we understand. You say that your land derives from that Jamavandi. Jamavandi is only 1 kata 2 lechas. So 1 kata 2 lecha in your schedule, it is 5.5 lecha. And otherwise it is not matching. Even with your arithmetic, you are unable to find out that land.
And in the partition deed also, it has been written as one
Therefore,
kata
the
two
entire
lecha.
land was sold. As per the sale deed to different number 7, by deed number 4/11/1993, the entire land in the Jamavandi was sold. The tafsil, the land is 1 kata, 1 kata 2 lesa. মাটির মধ্যে ওর নিচ অংশ 34 feet, 455 square feet land. Out of this land, 455 square feet land was sold. Now, according to you, the defendant number 1 who has sold the land to defendant number 7, how much share does he have?
It will be number 7.
Okay, you forget that arithmetic. Please tell me if I am wrong. 1 kata, 2 lechas. 1 kata would be how many square feet? 2880 square feet. 144 lecha, 144 square feet is 1 lecha.
144, yes.
144 is 1 lecha, so 2880 is 1 kata.
Oh, yeah.
Correct. And plus at 288, there is 1 kata 2 lecha, the total land will be 3168 square feet. 3168 square feet. If you say you are holding 1/4, so your share would be 792 square feet. Now you have purchased land from 2 persons. Now where are their names and how they devolve title to for you to purchase that land? If you can demonstrate, you have a case.
May I please, Your Lordship, kindly produce the map 21.
No, map is something prepared by you. This is not a revenue map. This is a part of that settlement deed. So whether that is right or wrong, we don't know. You derive your title from the entries made in the revenue records. Now, how does your vendor give you the title? There are only 2 purchase deeds, and you say that apart from that, you own by way of ownership. How do you do that arithmetic and show us? Because if you claim only 1/4 share, so that would be 1792, and out of the remaining share, if 455 square feet is sold, you cannot be aggrieved. And in this Jamabandi, which you have shown to us, there are only name of 6 people.
Sultan and Multan also there, Your Lordship.
Yes,
On the
Sultan,
east.
Sultan,
Sultan and Multan.
Ehsan, Mathiur Rahman, Anisur Rahman. So these are 5 people, and the original landowner's name is still there. Konokeswar Hoikia for (455 square feet) in dag number 683. That is perhaps the land sold.
The kindly please page 43. All the details of share is
Just a moment. Where is the appellate order?
affiliate order. Page number 7.
What according to you is the error in the first appellate judgment?
First appellate judgment. May I please kindly please the ground of PW, 8 PWs and 2 DWs were examined, and the appellate court, the learned trial court did not consider the evidence of any PWs and DWs, and exhibit. Similarly, the learned lower appellate court also did not, the learned trial court referred to the two registered partition deed, exhibit 2 and 3, which were 30 years old document and admitted without objection. But refused to consider them, stating that they were unregistered documents.
You see, even the first appellate court proceeded in the same fashion which the first question which I asked. It said that this Badal did not have a title. And therefore, it was rightly said that this land was not devolved to a land. It was purchased land from Sivanath Sharma. And therefore, this Badal would not have a share.
But
So
in the
therefore this-
written statement, different number 1 and 2 also says that.
No, but that's why how the title is devolved is the first question is from the source of the title. You see, three people coming in and saying that this is my property would not make it their property. Even if the document is an old document, but the title was devolved from some source. That's why I started by saying that unless you show me the source of title, I'll not be able to follow you. Same thing has happened with the first appellate court. The source of title was not found and therefore your appeal was dismissed. And in this case, when there was a discussion on the relevant issues, non-compliance of Order 41 Rule
Order
31 may be excused.
Memo. Your Lordship, DW1 Ehsan Ali also says that our grandfather's name was Badal Hussain, who had 4 sons, namely Sultan, Multan, and Khalil. The Ajmali Patta is in the name of Sultan and Multan.
You have shown us the Jamabandi. The Jamabandi's name is not there. And it is a purchased land. Name of Badal will not come. It will be just a wishful thinking. How will the name of Badal come? Even if you agree to an partition. But if by way of a partition, a person who is not the owner of the land gets a share, then that document becomes compulsory registrable document. Under section 17(1). You see that there was your case is that there was a family partition in your evidence. The case is that there was a family partition. That's why the plaintiff is not very clear. In plaint, you don't say that it is a family partition. Please come to the plaint. See paragraph 3 of the plaint at page 41. You say previously Sultan Sheikh and Multan Sheikh were enjoying possession after purchasing it from Sivanath Sharma. Then they obtained mutation, correction of records. The plaintiffs are from the same locality. That Badal Hussain was the grandfather of the plaintiff, so and so. All sons of so and so. On so and so partition deed of agreement to partition the Sutlam was the son of Badal as per registered partition deed. Now there is a finding of the trial court that only 2 people had signed. The signature of all people who were the owners of the land was not there. And then you say they were enjoying possession. So that means you are a stranger. If you are claiming through Badal Hussain, you would be a stranger.
And your lordship, both the court not dealt with the prayer of the plaint also.
What is the prayer?
Kindly peruse page number 7, paragraph 4. The plaintiff therefore praised that plaintiff number 1 and 2. And
Right
he
title
pro-
interest in 1/4 share.
yes, your lord. 1/4 share.
That you don't have. Because the court now cannot, you see, even the partition deed, the court cannot take into cognizance that, because once it creates title over the land and it is registrable under section 17 of the Registration Act, then there is a bar under section 49 not to read in evidence a document which creates right title interest over a plot of land. You see, in the title suit, come to page 31, the issues are 6. Any cause of action for the suit, whether the suit is barred by limitation, whether the suit land is an ancestral property, whether the plaintiffs and defendants executed amicable settlement possession of the possession. Number 5, whether the defendants trespassed,
The land.
what are the reliefs. Now, please come to discussion of issue number 3.
Issue number 3 and 4.
3 is page 31.
Yes, your lordship.
Suit to some person other hand to admitted the claim of
The defendant stated the suit land has been
Got
owned by
by
Sultan Sheikh
so-and-so.
and Multan Sheikh.
Thus, upon the repairing of the plaint as well as evidence of the plaintiff is inconsistent and contradictory. Lacks material particulars.
In the plaint also, it has been covered within the Patta number 52, Dag number 653, ward number 2 of Bihupuria Mauja. 1/4 share of total 1 kata 2 lasses of land belonging to plaintiff number 1 and 2.
Same is equal to 5.5 lashes. But we claim to Badal. And this is specific finding at page 33. As such, Sultan and Multan along with Abdul Aziz and so and so happen to be the sons of one. This is Badal Hussain. There is no plea in the plain to show that this is Badal Hussain had owned and possessed this land. Once your title goes, other prayers are not required to be considered. You should have taken the opportunity given to you in issue number 6. You got an opportunity and you missed the bus. Page 34.
Issue number 6.
Sorry, we don't
But
find
the-
merit.
Commission was not appointed.
Commission will never be appointed. If the court is not exercising jurisdiction to have a partition suit, the commission will never be appointed. You see, what is the dispute? There is absolutely no dispute, but the court arrives at a finding on issue number 2 that you don't have a title. So if you don't have a title, when will a commission be issued to find out your land? Yes, sorry, Mr. Bhattacharya. Yes,
Your Lordship, kindly peruse page 33. It was found to be illegal, for which it cannot be stated that plaintiff and
Correct.
defendant executed any amicable settlement.
did
in
not contain
connection-
the sake of Multan Sheikh. That is a fact. Your evidence doesn't show that. So deed of partition without the signature of an owner would be illegal. You see, today you are arguing a matter before us. Right now, somebody forges your signature, without your signature, files a partition agreement before the sub-registrar office. What would happen? About 30 of us in the room will be a witness that at 11:45 you were arguing. You could not have been there and the same time in the sub-registrar office to execute the deed.
But sub-register office also said that it is an ancestral property. Sub-register.
Sub-registrar. Sub-registrar has no authority to say anything.
But it is a registered deed, Your
If it
Lordship.
is the land, it is, you see, it is your case that so and so purchased the land from Shiva Kumar Sharma. That is your pleaded case. How can that be an ancestral land then? You could have said that it's an ancestral land so far as the title from of this Sultan and Multan was there. So from Sultan and Multan, how does this Badal come? That relationship is neither proved under section 50 or 112 of the Evidence Act. Yes, Mr. Barua.
I can say, Lordship already on taking note. Yeah,
No, but you can still admit,
but the
but you can still admit.
page 34 was in fact question not no, yes, page 34 that 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 say that they get giving them the opportunity by court opportunity, finding that their whole case was based on that partition. They are says that exhibit 2 and 3 are false. Their statement, their judgment is reflected there. And they could have established the title of body land. How the court can pass and partition debate. That is rightly the court decide that your filing should separate should. In the meantime, perhaps not coming to the court, this court, if they had filed a suit, this directed to take a file to separate suit for partition. In absence of partition, there should be right title interest of 20 and content of page 7. Because their whole case based on the document which is not moved. The civil code, only lordship know the civil code only that it is the right of the parties and the share thereof. They can do. The partition goes to the that's what section 97. But they could not find it. The court rightly hold that and there in their case, even another aspect is there that the court indicate that their plain they said some of portion has been sold to the someone. And that is the access to the share of the whole share. But they never, their statement, they indicate, they never find for the recovery of that area also. Or nor the cancellation of that.
Indeed, there is a prayer for cancellation. No, but there is a prayer for recovery. There is a prayer for recovery. Go. That the plaintiff be given a decree for cast possession upon ejectment of defendants from the illegal possession. So there is a prayer. Sorry, the title is not there. Heard Mr. K, Miss K. Bhattacharya, counsel for the.
Yeah, you can kindly give some time for.
No, this is 2009. You are hearing it after 17 years.
Or your lordship, my humble submission is that kindly remand the case.
No, there is no case of remand made out. You got some time by default because my secretary is not there. You ask for time, you are giving it. Till my secretary comes. Yes, Mr. Sharma, you are admitting her case? No? You are with Mr. Barua?
Yes, yes.
Okay.
Yes, এখানে যেটা সুবিধা থাকছে যে একটা টাইম টোটালি টাইমটা যদি বলে লিমিটেশন গুলো যদি দামটা সবাই দিলে সেগুলি বাকি রাখতে বেশ দেরি হয়ে গেছে না কি ওটা উপরে কাজ করে দিতে
একটু এটা করবো বলি একটু এটা করবো
That's it. माहिती उपाय पण निमित्ताने पाहिजे अस्पेक्ट होते जिथे आहे त्याच्यावर माझं बुद्धी बोलून I'll just take a short break and come back.
Issue this from the
Like to me, move the part two. Definitely, I mean, side to limitation to on.
Your Lordship, as per issue number 6,
Issue number 6.
kindly granted liberty to explore the remedy to issue number 6 and limitation may be granted to file a fresh suit.
Well, I'm dictating, I'll consider it. Right. Just keep it attached and also for the appellant. Appellants. And Mr. P.P. Barwa, another counsel appearing for counsel appearing along with Mr. R. Sharma and counsel for respondents, all the respondents. Next one. The appellants herein where the tentative numbers 3 to 7 in TS number 10 of 2002, which was filed and adjudicated before the Court of Learned Civil Judge within bracket Senior Division, bracket was Lakhimpur. In brief, you first say that this appeal under section 100 CPC is directed against the first appellate judgment and decree dated 13/6/2008 passed by the learned additional district judge within bracket FTC, bracket was Lakhimpur, North Lakhimpur, in TA 15 of 2006. By the said judgment and decree, the appeal was dismissed and the judgment and decree dated 6/9/2005 passed by the learned civil judge within bracket Senior Division, bracket was Lakhimpur, in TS number 10 of 2002, for thereby dismissing the suit was affirmed. Next one. In brief, the case of the appellants in the suit was that Previously, two persons, namely Sultan Sheikh, Sultan and Multan Sheikh, Multan, Sultan Sheikh, were enjoying possession over the suit land after purchasing the same from one Shivanath Sharma, Sivanath Sarmah. And accordingly, the land was mutated in their names by order dated 6/6/1933, and consequential correction of the revenue records was made. Most of the land, the purchased land was measuring 1 katha 2 lecha, covered by Dag number 33 or Pata number 33. Which is which at the time of filing of the suit was covered by Dag number 653 of Pata number 52 under number 1 ward of Bipuria, Bihpuria, Moza. The It was stated in the plaint that late Badal Hussain was the grandfather of plaintiff numbers 1, 3, 4, 5, 6, and 7. So he said Badal Hussain had 4 sons, namely, Abdul Aziz, AZIZ, Muhammad Khalil, Muhammad Sultan Sheikh, and Muhammad Multan Sheikh. The plaintiff number 1 is the son of Muhammad Khalil, and the plaintiff numbers 3 to 7 are the sons of Multan Sheikh, and the plaintiff number 8 is the wife of Multan Sheikh. So stop, please. Claim that by virtue of partition deed dated 21/8/1961 and deed of agreement for partitioning the suit land dated 18/3/1971, the suit land was partitioned amongst the sons of late Badal Hussain. It is projected that the partition was by way of a registered deed, and accordingly all the sons and the heirs of late Badal Hussain were enjoying undisturbed possession over their respective share of land. Full stop. It is also claimed, it is also projected that on a complaint made the names of defendant numbers 1 to 4 which were entered into the chitta were deleted, and the names of Sultan Sheikh and Multan Sheikh were entered in the patta. It is also projected that on 21/3/1993, there was an amicable partition of the suit land, and all the respective parties had put, and the witnesses had put their signatures on the map. With definite boundaries shown therein. And that each of the parties were enjoying possession of their respective share as shown in the sketch map dated 21/3/1993. Full stop. In case of the plaintiffs in the case set up by the plaintiffs in the plaint is that at about 3:40 a.m. on 6/4/2002, the shops and houses on the rented houses on the suit land were gutted by fire, and taking advantage of the situation, the defendant numbers 1 to 4 took possession of more than their share and thereby disposes the plaintiffs from their share. To stop. Subsequently, the defendant number 1, by executing deed, the sale deed dated 4/11/1993, sold more than his share of land to defendant number 7. Accordingly, it is claimed that defendant number 7 was the illegal possessor of the excess land. It is also claimed that the plaintiff number 1 and 2, in addition to their 1/4 share of the entire scheduled land, the plaintiff number 2 has additional half share of the land by virtue of his purchase from Muhammad Tarsullah's TASRULLA apostrophe S, half share. It is also projected that the plaintiff numbers 3 to 8, in addition to the joint share, 1/4 share in the land, the defendant, the plaintiff number 8, is also the owner of the land purchased from Matiur Rahman. Full stop. The defendant number 5, in the meantime, had also sold his share of land to the plaintiff number 8 and handed over possession of the said land. And the defendant number 5 had also sold his share of land to defendant numbers 8 and 9. So accordingly, is also proposed of. It is stated that the persons in possession of the land were not the owners, but it is pro forma defendants. Accordingly, the plaintiffs had filed a suit with the following prayers, page 47. What to Chaw, page 47. The land described in the schedule to the plaint is also extracted below. This is 47, 48. Next paragraph. The defendant numbers 1, 2, 5, and 6 filed their written statement cum counterclaim wherein it was denied that Badal Sheikh was the legal patadar of the suit land. And accordingly, his legal representatives had no right to get partition of the suit land. In respect of the land purchased from Muhammad Tarsullah and Muhammad Idrish, it was stated that they did not get mutation by right of inheritance, and therefore the vendors might take possession by right of their title acquired through purchase, but it would only be the seller would only be responsible, and those persons, namely Muhammad Idris and Muhammad Tarsullah, TSRULLA, can claim land from the seller's share. Full stop. It was stated that none of the defendants had accepted any partition or map. It was stated that, and it was denied that the defendant numbers 1 to 4 had put their signature on the sketch map, and that the said sketch map was drawn after cancelling the previous partition as illegal. So accordingly, claiming that the said defendants had taken our position of half of 1 kata to Lecha, which is their father's share. The rest of the statements in the plain were denied, including the challenge to the sale of land by defendant numbers 8 and by sale of land by defendant number 4 in favor of defendant numbers 8 to 9. Full stop. Accordingly, it was stated that the plaintiffs were not entitled to any reliefs, and accordingly, in respect of the counterclaim, it was paid that the NHS 2 and 3 of the plaintiffs and the sketch map showing partition be declared as illegal and for compensation. Separate set of written statements were filed by defendant numbers 7 and 11, by which the defendant number 7 asserted possession of the land purchased through registered deed. And claiming right over the land which was purchased from the defendant number 1 by registered sale deed at 4/11/1993 in respect of 455 square feet of land. Next paragraph. Plaintiffs filed the a separate set of written statement was also filed by defendant numbers 8 and 9. Claiming purchase of land by deed number 61 dated 2/1998 from Anisul Rahman, measuring 250 square feet out of 1 kata 2 litres of land of this woodland. And paid for dismissal of the suit. Next part, the plaintiffs have filed their written statement against the counterclaim. Denying the claim of the counterclaimants. Denying the right of the defendants to be entitled to declaration that the settlement numbers 32/71 and partition register number 596 of 61 were ineffective. So it was also asserted that the defendant numbers 4 and 6 and the plaintiff number 1 had jointly mortgaged their share of 1 kata 2 lachas land of flag number 653 to the plaintiff number 3, and the said land was freed from mortgage on 21/5/1976, and thereafter defendant number 4 sold ten lacha 66 square feet of land to one Anjali Srimati Anjali ANJALEE Bora BORA Deori DEORI on the strength of the earlier deed of partition. It was stated that the defendants had lost the right to claim for cancellation of the sketch map or the sketch map dated 21/3/1993, and claiming that they have been in possession of the land. So it was also stated that the defendant number 6 had filed a case before the Assam Board of Revenue bearing number 131 RA within bracket L bracket closed oblique 94 against the plaintiff number 1, and it was stated that having failed to come out successful in this revenue case, the defendant number 6 had moved the High Court by filing civil rule number 4820/95, and having not succeeded, the present counterclaim has been filed. So accordingly, denying the counterclaim, it was made for dismissal of the counterclaim. Next paragraph. On the basis of the pleadings, the learned trial court had framed the following 6 issues. I put a flag. There's no page numbering. There's no page numbering. It is a certificate copy. Oh, okay, it is there, in another page. It will be page 31. Next, before the learned trial court, the plaintiff side has examined there were 8 witnesses, right? 8 witnesses. Can you give me the names of these witnesses? Can you write it down and give it to me?
Question?
The names of these 8 witnesses examined.
Yes.
And for the defendants, how many witnesses were there? Make a photocopy of this. Just make a photocopy of this. Photocopy कर लो. Right, okay. No. This page there, 8 witnesses, the following 8 witnesses were examined, and the defendant side examined 2 witnesses. And the following documents were exhibited. That documents will be at page 50 of the TCR, file number 3/5. This is file 3/5. There is the exhibit, with the copy of Jamabandi, exhibit 1, Batwara agreement, exhibit 2 and 3. It's like this, just give the serial numbers. Huh? There are 27 exhibits. And there is file number 4/5. There you will find the defendants exhibits, page 17. This is exhibit Ho. It goes like that. That's fine. Having regard to the proceedings and evidence on record. So for issue number 2 and 3 is concerned, they were taken up together and the learned trial court on the evidence of the plaintiff, namely after A, B, T, A, B, after Valam, to be inconsistent, contradictory, and in view of the pleadings that the land was purchased by Sultan Sheikh and Multan Sheikh, it was held that there was no plea in the plaint that Badal Hussain had owned and possessed the Suitland at any point of time. So moreover, as Exhibit 2 and 3 did not contain the signature of Multan Sheikh, the said document was held to be illegal, and accordingly, as there was nothing on, there's nothing to show that the land was purchased by Sultan and Multan. The amicable partition was not found to be in accordance with law, and accordingly, the Suitland was not found to be ancestral land of the plaintiffs and the defendants. And moreover, it was also held that it cannot be stated that the plaintiffs and the defendants had executed an amicable settlement for possessing their respective shares, and accordingly, both the issues number 3 and 4 were decided in negative and against the plaintiffs. Full stop. Accordingly, there was no requirement of, accordingly, in respect of issue number 5, it was held that in view of the discussions on issue number 3 and 4, issue number 5 is not required to be discussed. So, in respect of this, on the issue number 2, it was held that the suit was filed within the period of limitation, and that there was cause of action for the suit, and in respect of was decided in respect of issue number 1 and in respect of issue number 6, the plaintiffs were not found entitled to partition in the instance suit. In view of the provisions of Assam Land and Revenue Regulation for partition, and accordingly, the plaintiffs were directed to take resort to file a separate suit for partition. So accordingly, in the absence of partition as well as right that in the interest of the plaintiffs, the plaintiffs were not found entitled to any relief. Stop. Next, the The present appellants were the plaintiff numbers 3 to something wrong again here. Page 21. If something is wrong, you see, come to page 35, but page 35 is the decree,
Yes, Your Lord.
correct?
Yes.
Here, look at serial number 8 of plaintiff, Musammat Hedayut Nesa, correct?
Yes.
Now come to page 21. Hedayatun Nisa, wife of Multan Sheikh. Now she has become at serial number 6, Musammat Bedayatun Nisa. How can that not have 31? On page 39, the spelling is again different. Amended plaint,
Most of it,
Hedayatun.
Hedayatun.
There is a change of names.
Yes, Your Lord.
You see that the present appellate numbers 3 to 8 had preferred an appeal against the judgment decree passed by the Honorable High Court. Just it may be stated that the name of the appellant number 8 is found to be differently spelled. In the plaint and plaint decree and the memo of first appeal. So in the amended plaint, the name of the defendant number 8 is Musammat MUSTT, full stop, Hedayatun, HEDAITUN, Nesa, NESA, wife of Multan Sheikh, MULTN, SEIKH. So in the decree, her name is spelled as Musammat MUSTT, Hedayut, HEDAYUT, Nesa, wife of late Multan Sheikh, SK, this time, SK. And in the first appellate decree, her name is spelled as Musammat MUSSTT, Bedayatun, DEDAYATUN, Nasa, wife of late Multan Sheikh, SHEIKH. Be that as it may, her identity is not being disputed at the bar. The learned first appellate court did not formulate a point of determination. However, by the first appellate judgment and decree dated 13/6/2008, passed in TA 15 of 2006. Upon discussion of all the issues, based on the evidence and pleadings on record, the finding on all the issues were affirmed. And accordingly, the appeal was dismissed. Next. This appeal under Section 100 CPC has been admitted by order dated 27/2/2009 on the following substantial questions of law. This will be order sheet page 2, green pack. 3 issues. Next one. The learned counsel for the appellant has accepted the stand taken in the plaint and in the memo of first appeal, and has submitted that the learned trial court had, learned first appellate court had committed grave error in not formulating points of determination in the order 41, rule 31 CPC. Stop. Moreover, it is submitted that the learned first appellate court did not discuss all the evidence of all the witnesses examined and did not refer to all the exhibited documents. Which, according to her, initiated the proceedings. So it is also submitted that similarly the learned trial court had also not discussed all the evidence and exhibited documents. Referring to the evidence of DW1, it has been submitted that the defendant number 1, DW1 admitted that Badr Hussain was the grandfather and had admitted that the plaintiff numbers 3 to 8 were sons of Multan, and they were 4 brothers having Ismaili Patta in the name of Sultan. So thus comment is submitted that the partition was not in dispute and rather proved by the plaintiffs and the defendants, and therefore exhibit 2 and 3 is required to be properly appreciated and considered. Next paragraph. This, in this case, going to the unique facts, it is noted that not only trial court had not referred to all the evidence and the exhibited documents, and neither the first appellate court had referred to the elaborately dealt with the evidence of the witnesses examined and the exhibited documents. Full stop. Therefore, it is required to be examined as to whether any impropriety was committed by both the learned courts below in not referring to all the evidence on record and without this and on its failure to discuss the document evidence exhibited. Next paragraph. From the pleadings made in the plaint, the plaintiff numbers 3 to 8 for the appellants herein claim the right that an interest in respect of 1/4 share on the suit land, specific prayer for declaration of the right at an interest and for recovery of possession after ejectment of the defendants who were found to be in illegal possession. Most of the plaintiffs was also prayed for issuance of a commission for measurement of the land. Full stop. Next paragraph. The specific pleading in the plaint is that previously Sultan Sheikh and Multan Sheikh were enjoying possession of the suit land after purchasing the same from Sivanath Sharma. Full stop. The sale deed which Sultan Sheikh and Multan Sheikh had purportedly purchased the land from Sivanath Sharma has not been exhibited. the plaintiffs, in order to assert title over this land, had exhibited the draft Jawabandi as Exhibit 4. In respect of land covered by Pata number 33 old 32 oblique 32 U. Measuring 1 kata 2 lecha. How that the document is only a draft Jawabandi and not a final Jawabandi. The final Jawabandi, which was exhibited by PW6, is marked as Exhibit 11, which contains the name of only Sultan Sheikh and Multan Sheikh as the recorded patadar in the said Jawabandi. Therefore, comma, moreover, the old Chitha was also exhibited by PW6, and the entries were marked as Exhibit 12, 13, and 14 respectively. All the 3 entries reflect the name of Sultan Sheikh and Multan Sheikh. As the patadar of the said land. Therefore, comma, add also 15. 16, another Jawabandi is exhibited as Exhibit 17 by PW7. So, how the said land measuring 1 bigha 3 kata 14 lecha is found to be covered by that number 20. There's no pleadings or evidence on record to link the said 1 kata 3 lecha 14 1 bigha 3 kata 14 lecha land of dark number 20 with the straight line. And when the straight line is 1 katha, 2 lechas, it will be impossible to connect the said land with a larger plot of land measuring 1 bigha, 3 katha, 14 lechas. Of the PW7 is also exhibited another Jamabandi as exhibit 21. Which measures 1 katha 2 lecha covered by dark number, sorry, pata number 52. It contains the names of other patadars. So, except for the duration of the name of Sultan Sheikh, the relevant entries are by way of purchase and possession. So therefore, comma, no, not therefore, there is one more doctor. The same Jamabandi is again exhibited as exhibit 25. And exhibit 26. So, on a perusal of the document evidence on record, there is no evidence shown as to how the name of Badr Sheikh, how in the name of Badr Sheikh any share of land would fall. Full stop. Therefore, comma, even if there is a partition between the parties who would otherwise have derived like title and interest of this land, comma, deed of partition creating or extinguishing right over a plot of land which is valuable more than ₹100 is required to be compulsorily registered as per the requirement of section 17(1). B of the Registration Act 1908. Therefore, any document which is required to be compulsory registered. Cannot be read in evidence in view of the bar created under section 49 of the Registration Act. Full stop. Next paragraph. Thus, in this case, there is no document which validly creates any right on any of the plaintiffs, deriving title from Badal Hussain. Is it Badal Hussain or Badal Sheikh? Badal Hussain. Full stop. Next paragraph. Therefore, once there is a lack of title in favor of the plaintiffs, the court does not find any error in the judgment decree passed by the Learned Trial Court as well as the Honorable First Appellate Court, and not dealing with the evidence which is otherwise unnecessary. Full stop. Next, it's a well settled principle of law that though entries in the Jamavadi would have some relevance under section under regulation, not section. One under regulation 40 of the Assam Land and Revenue Regulation, 1886. Full stop. However, when the plaintiff asserts title, mere entry in the name of Jamavandi, not supported by any deed of title, would not confer on the persons whose name is recorded in the Jamavandi or in the Chitta, confer proprietary right over the suit land. So once the plaintiffs approach the court to file a civil suit and assert their right title and interest, and correspondingly pay for a declaration of right title and interest, court is unable to accept that mere entry in the name of in the Jamavandi, or in the absence of any title, would confer any right better than one which is conferred on the purchaser of the land. Full stop. In this case, the title deed of the original owners of the suit land, namely Multan Sheikh and Sultan Sheikh, was also not exhibited. Sorry, first is Sultan Sheikh and then is Multan Sheikh. So as per the revenue records, the name of Multan Sheikh has been struck off. which is reflected in the Jamanti exhibited as Exhibit 21. And Exhibit 25. Next, therefore, comma. The evidence of the witnesses would not create, even if thoroughly examined, would fail to create any title in respect of the appellant's plaintiffs. Therefore, comma, the suit not being a suit for partition, and no prayer was made in terms of, as per the requirement of a partition suit, paying for a preliminary decree and to determination of shares of the sharers of the land. Comma, the learned trial court had rightly dismissed the suit. Next, similarly, comma, the learned first appellate court, though did not frame any points of determination as required under Section 41 or Order 41 to 30, Order 41 to 31 CPC, but in this case, comma, the learned first appellate court had dealt with all the issues, and therefore, when there is no document of title to show the title of the plaintiff, comma, the non-framing of the points of determination as required under Order 41 to 31 of the CPC is not found to be fatal. Stop. So in the case of the appellants as plaintiffs is that the derived title through Badal Hussain, and there is no reflection in any of the documents as to how Badal Hussain, although he may be the elder brother of Sultan Sheikh and Multan Sheikh, would not create any proprietary right just to be inherited by any of the appellants who are the plaintiffs number 3 to 8 in this suit. Stop. The plaintiffs number 1 and 2, having not filed any appeal, has accepted the decree of dismissal of the suit. Therefore, comma, so the court has referred to the pleadings and the evidence and has referred to the witnesses examined, but a discussion of all the all the witnesses and their evidence is not found necessary, as the plaintiffs could not show their title to have so as to have an effective partition of the suit land amongst the members of the family. Next, accordingly, comma, the first substantial question of law is answered by holding that the court does not find any perversity in the judgments and in judgments passed by the learned trial court and the learned first appellate court on account of non-consideration of oral and documentary evidence and moreover, comma, there is no evidence which has been either misread by the courts below. So accordingly, the court does not find any non-application of mind in the present case. Next paragraph. In respect of the substantive question of law number 2, for the reasons already assigned above, and in light of the discussions above, when the appellants as plaintiffs claim title and they fail to show the title, or there is no other requirement to appreciate all the evidence on record. So it is not the evidence which creates title, but the title would be created only on the basis of a title deed, in whatever form, but it should be lawful and admissible in evidence. So in this case, there is no document which creates title in favor of any of the plaintiffs. Next, in respect of substantive question of law number 3, first of all, the court finds that the learned courts below arrived at a correct decision that the suit in that suit, decree of partition could not be permitted. So though the language used may not be perfect, so in this case, the suit was not filed for partition, and accordingly there was no prayer for passing of a preliminary decree to establish shares determined in accordance with the suit for partition. So in this case, the prayer made in the plaint is for a simply cited decree of declaration of right title in interest, claiming title over the suit land. Therefore, as there is no evidence of title, no consequential relief would be granted otherwise. Therefore, while deciding issue number 6, the learned trial court did grant the petitioner liberty to move the revenue authorities under the Assam Land and Revenue Regulation for partition or to file a partition suit. So, next, there's no doubt that a civil court would have the power to partition the suit land and to determine the shares of the various sharers of the suit land. However, the present suit was not structured as a suit for partition, though the pairs indicate to the pair for partition. So, however, be that as it may, as the appellants are not found successful in showing their demonstrating their title, the issue as to whether the civil court could have ordered partition only be an academic discussion. Accordingly, the third substantive question of law is answered by holding that the court does not find any perversity in the finding of the learned first appellate court that civil court is not the proper forum for passing a decree of partition, which should be restricted only under the facts and circumstances of the case, as the suit was not filed for partition for drawing of a preliminary decree for determining the shares and thereafter to draw up a final decree, which is for which the plaintiff ought to have here in the nature of Rule 18 of Order 22 of the CPC. Nonetheless, in this case, as this court does not find the title to have been proved in favor of the appellants, there would be no requirement of passing any order for partition of the suit property so as to determine the shares of those entitled to next. Accordingly, the appeal fails and the same is dismissed. Next. At this stage, the learned counsel for the appellant has submitted that in view of the leave granted by the learned trial court while deciding issue number 6 to permit the appellants to file case for partition in the Assam Land and Revenue Division or to file a suit for partition. Full stop. To grant relief to the appellants in terms of the observations of the learned trial court in respect of issue number 6 would not be permissible at this stage because this concurring finding of fact regarding to the lack of title in respect of the appellants and therefore in the absence of title, it would be not permissible for this court to grant leave to the appellants to again approach the civil court and file a suit for partition. Next, accordingly, the appeal stands dismissed. Next, under the circumstances, there shall be no orders to cost in this appeal.
In for motion.
May it please your lordship. Yesterday, your lordship put a query to us that why we have not raised the counter claim. Lordship, as per my limited understanding, lordship, once the parties entered into a compromise, lordship, and the court passed a decree based on it, then the adversarial battle ends there, lordship. And also, lordship, if your lordship will look at the provision of Order 23, Rule 3. If I may read your lordship. Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise, or where the defendant satisfied the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a decree in accordance therewith. So far as it relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is the same as the subject matter of the suit. Lordship, the basic requirement is that court has to satisfy first. And if your lordship will come to the counter decree, compromise petition, your lordship, that your lordship will find at page number 26, your lordship. In all the paragraphs, they address us as counterclaimant. Though it has not been mentioned in the petition as well as in the decree, lordship, the basic essence of the compromise rendered useless if this decree does not surpass this counterclaim or the main suit. And also, lordship, we cannot go for appeal because there is a bar under 96.3, section 96.3. Counterclaim, lordship, I think is not NFC counterclaim, but it is mentioned in the decree itself. Decree, your lordship will find it page number 21, your lordship. But counterclaim is not mentioned here, but the schedule, this schedule has been properly mentioned here. It is basically, lordship, the dark number which is in dispute is in possession of the petitioners, the plaintiff, original plaintiff, decree holder. And dark number 390, which that is the schedule C, that is in my possession. Now our settlement is that we are going to exchange the land. when we have discovered this anomalies only at the later stage, when the demarcation order was passed by the Honorable Civil Trial Court, there is a shortage of land in the dock number 386, Your Lordship. The core, Your Lordship. Lordship, in this matter, tomorrow this matter is fixed for final report. The execution may be done any moment, at any moment. My house may be demolished, Your Lordship. That is why I stay at this stage. The core, Your Lordship. Yes, Lordship, one is 33 and other one is 20. Trial court amalgamated both the exhibition petition together. No, our case is 54. 54, sorry. I'm sorry, Your Lordship. 54, title exhibition 54. 54. Yes, that is mine. And 20 is there. So, Your Lordship. Recall the decree. Yes, Lordship. Remember to note that protocol. What protocol? Page 64, Your Lordship. Okay. 20. It's 54, 2024. The other one. 20. Yes. Yes. 386. My where I am residing right now is 390, no 390. Execution proceeding is still yellow. The house should not be demolished because yes, deeply well.
For hearing, item 4.
That in fact two orders formulating four substantial questions of law in total. No? First is the order dated 26, 2012, no? Whereby one question was framed. On 21, 3, 24, three more were framed. And This is the plaintiff's second appeal, The suit was initially decreed, however, in appeal it was reversed and suit was dismissed. Your Honor, page 36, Your Lordship finds the plain. Page number 36 is the plain. Lord, the facts otherwise are simple. I'm the plaintiff. Lord, the property in question belonged to the Chaudhary family, The case of the plaintiff is that in that entire family tree, the properties were amicably settled, and the suit property in question, the schedule you will also find at page 40, is what fell in the share of the plaintiffs by virtue of that family settlement. And the allegation basically is that from this particular share, which actually fell in the share of the plaintiff, the defendant number two executed a gift deed in favor of the defendant. I'm sorry, the defendant number one executed a gift deed in favor of the defendant number two. Well, Lord, for your lordship's convenience, if your lordship has this, My lord finds three brothers, Hemchandra Das Chaudhary, Kalpanath Das Chaudhary, and Ramnath Das Chaudhary. They were the three brothers, original owners. And we are mainly concerned with the heirs of Kalpanath Das Chaudhary. So, my lord, the fines in that family tree, my lord, we are mainly concerned with the heirs of Kalpanath Das, my lord. Now, Kalpanath Das had left behind three sons, my lord. Girish Chaudhary, he happens to be the defendant number one. Then there is Lakshikanta Chaudhary, he is no more, my lord. He is survived by the son Pabitra Chaudhary, who happens to be defendant number two. Insofar as the plaintiffs are concerned, my lord, they are heirs of the third son, two, gifted. Now, my lord, the basic crux of the dispute is the suit land. The plaintiffs say that this is our share as per the amicable division, and Girish Chaudhary, the defendant number one, illegally gifted it out to his nephew, who is defendant number two, Pabitra Chaudhary. That's the plain and simple case of the plaintiffs, my lord. We say that as per that settlement, this particular parcel of land is exclusively in our possession, and we are residing therein. So therefore, the gift deed, insofar as it relates to these particular dads, is bad in law. Now, Lord, if your Lordship has the written statement, which your Lordship finds at page 41, the factum of amicable division is not disputed, but perhaps this is the valuable parcel of land. They say, as per that amicable division, it fell in our share, the defendant number one says. So, now page 42, your Lordship will find para 6. Amicable division is admitted, but they say, as per that amicable settlement, this fell in the share of defendant number one, so he had the alienable right to sort of give the property to defendant number two, and that is also the stand of the donee, and that written statement is at page 44, my lord. He also maintains that it fell in the share of Girish Chaudhary, and he rightly sort of gifted it out to the defendant number two. Now, my lord, trial judgment, your lordship finds at page 22. Now, if I may draw your lordship's attention straight away to the issues, which are at page 24. Now, issue number 4, 5, and 6 are perhaps the most vital issues, my lord.
Page 26, my lord, the issue number 5 was taken up first, my lord, before deciding issue 4. Page 26, para 17. If I may read this. Lord, so my lord, page 26 is issue 5 and issue 4 is page 30. My lord. So I'll begin with issue 4. my lord. So this is regarding Girish Chaudhary's right to transfer the land. That is at page 30. I'll come back to issue number 5. That's concerning the validity of the gift deed. My lord has page 30, para 23 onwards. PW4, that is plaintiff number 3, Dizendranath Chaudhary deposed in his examination in chief that his father Horonath Debo Chaudhary got 2 bigha 13 lechas from Dag number 1017 and 1 bigha 1 kotha 18 lechas of land of Dag number 1019 and 1 bigha 13 lechas of Dag number 265, 266, 333 and 334. Further, he stated that the land of Dag number 1042 mentioned in the gift deed is in possession of Authorised Chaudhary and he is the owner of the said land. PW5 deposed in his evident examination in chief that a plot of land measuring 2 bigha 3 kotha 6 lechas covered by Dag number 1017 is in possession of plaintiff. Since last 40 years, and the land measuring 1 bigha 1 kotha 3 lechas covered by Dag number 1042 is in his possession. The defendant number 2 in his cross-examination as DW1 stated that the case is running for the land where the plaintiffs are residing. From cross-examination of DW1 and 2 and from the contents of from Exhibit 1 co and Exhibit 4, it is seen that the defendant number 1 did not deliver possession of the land gifted by him to the defendant number 2, and from the evidence of the witnesses, it is seen that the plaintiff and the pro forma defendant Authorised Debo Chaudhary are in possession of land of Dag number 1017, 1019 and 1042 of Patta number 57 and land measuring 12 bighas 10 lechas covered by Dag number 265, 266, 333 and 334 of Patta number 72, which falls in their share in amicable partition from Exhibit 1 and 2. It is seen that plaintiff number 2 and 3, defendant number 1 and pro forma defendant. Authorised Chaudhary are pattadars of Patta number 57 of Patsala town and plaintiff number 2 and 3 and defendant number 1 are the pattadars of patta number 12 in Patsala town. Hence, they are entitled to right title and interest and confirmation of possession over the said land. This issue is decided in affirmative and in favor of the plaintiff. Now, if I may take your lordships back to page 26, Manoj. The gift deed has several documents. I'll just indicate. It covers patta number 77, 72, and 57. Manoj. Patta number 77, 72, and 57. Now, we have categorically stated in the plain that insofar as 77 is concerned, we have no objection. But patta number 72 and 57, according to us, is the plaintiff's share and also the share of the pro forma defendant number 9. So declaration was also sought to that effect that these are the patta number 72 and 57 are the parcels belonging to plaintiffs and the pro forma defendant. Now, my lord, at page 26 again, if I may read. Paragraph 18, PW2 deposed in his evidence that 3 sons of Kalpanath Chaudhary, namely Girish Chaudhary, Lakshi Chaudhary, and Haranath Chaudhary, the 3 sons of Kalpanath Chaudhary get 4 bigha 16 lechas of land each from their paternal property of 12 bigha 2 kotha 8 lechas, and they are enjoying their shares. Defendant number 1, Girish Chaudhary, is his uncle. When Girish Chaudhary became mentally imbalanced, then he donated 2 bigha 2 kotha 6 lechas of his land and 1 bigha 1 kotha 3 lechas from Dag number 1042 to defendant number 2 by gift deed. But this land belonged to him and his brother Dizen Chaudhary, and they are possessing the land since 1968. And the land of Dag number 1042 is possessed by Horesar Chaudhary. From the evidence of PW3, it is seen that Girish Chaudhary, the defendant number 1, gifted 5 bigha 6 lechas of land to defendant number 2, Pabitra Chaudhary, from different Dag of patta number 57, 77, and 72 of Patsala town. And the deed was executed on 13/3/1998, and the same was registered on 20/3/1998. The plaintiff 3 deposed in his evidence as PW4 that Kalpanath Deba Chaudhary is their forefather, and he had 3 sons, Horesar Chaudhary, Girish Chaudhary, and Lakshikanta Chaudhary. They partitioned their land verbally on compromise, and they had to get 4 bigha 16 lechas of land each. His father, Haranath Chaudhary, got 4 bigha 4 lechas of land. In his share, 2 bigha 3 kotha 6 lechas from Dag number 1017 and 1 bigha 1 kotha 18 lechas from Dag number 1019 of patta number 57 and 1 bigha 13 lechas of Dag number 265, 266, 333 and 334 of patta number 72, and they are possessing the said land since the time of their father, and their names are mutated in the said land. The defendant number 2 had obtained the gift deed number 126 dated 23/1998 from the defendant number 1 in conspiracy of the said land. The land of Dag number 1042 mentioned in the deed is the land of Horesar Chaudhary's share, and he is possessing the said land. In cross-examination, he stated that the land of patta number 57 and 72 are Ajmali between them and defendant number 1, Girish Chaudhary. He denied Girish Chaudhary has shared in the land of patta number 72. Girish Chaudhary, the defendant number 1, got his share of 4 bigha 16 lechas of land in patta number 67. From the evidence of PW5, it is seen that Haranath Chaudhary, the father of the plaintiff, got 4 bigha 4 lechas in his share, about 6 kothas of land bounded by North Profullo South Road, East Mohinath and West Kishore, and land measuring 2 bigha 3 kotha 6 lechas bounded by North Road, South Kumut Talukdar, East Kishore, and Dizen Chaudhary of Dag number 1017 were possessing by plaintiffs since last 40 years, and the land measuring 1 bigha 1 kotha 3 lechas of Dag number 1042 bounded by North Toroni Medhi, South Rajani Bipin Chaudhary, East Mohinath Chaudhary, and West Rajani Chaudhary is possessed by him as his plot of land belongs to his father. The land mentioned by him in above three boundaries were never possessed by the defendant number 1, and defendant number 2 also never possessed the land of the said boundary. Defendant number 2 deposed in his evidence as DW1 that as heirs, they settled the property of their forefathers by making partition amongst themselves, and late Girish Chaudhary, that is defendant number 1, is the owner of the property of this case. That Girish Chaudhary had no issue and Girish Chaudhary was living with him till his death, that the land of the schedule of the plain falls in the share of Girish Chaudhary, and he executed the gift deed on 4/12/1998 by deed number 126 dated 4/12/1998. That said, Girish Chaudhary was fully conscious at the time of execution of the gift deed that the possession of the land was given to him after execution of the gift deed, that the offer and acceptance of gift was complete, that there is no cause of action for trial of the suit, that Exhibit Q is the original gift deed executed by Girish Debo Chaudhary filed by him, that he is the rightful owner and possessor of the property of the gift deed. In cross-examination, he stated that Kalpanath Chaudhary has 15 bighas, 18 lechas of patta number 57 of Patsala town. He does not know the dag number of the patta. He does not know the share of Lokhi Kantor's land. He does not know the dag number and area of land which falls in the share of Horonath. He does not know the area of land in dag number which was enjoyed by Horonath Chaudhary. He denied that 1 bigha 1 kotha 3 lechas of dag number 1042 falls in the share of Horesor, and land measuring 2 bigha 3 kotha 6 lechas of dag number 1017 is possessed by plaintiff. He has possessing the land of dag number 1017. The boundary of land of dag number 1017 North Road, South Kumud Talukdar, East Kishore Chaudhary and West Dijen Chaudhary, the plaintiff. He stated that in Exhibit Q it is not mentioned that the possession of the gift deed was delivered to him. He denied that he has no possession in the land of 1 bigha 3 kotha 6 lechas of dag number 107 and 1 bigha 1 kotha 3 lechas of dag number 1042 of patta number 57 and land measuring 2 bigha 1 kotha 6 lechas of patta number 72 of Patsala town. He denied that as Girish Chaudhary had no possession over the land, so Girish Chaudhary could not deliver possession to him. In the land of dag number 1017, there is a basti in one part and paddy cultivation in another. The case is for the land where the plaintiffs are residing. Further, he stated in his cross-examination that after execution of the gift deed, witnesses went away and Girish Chaudhary also did not come out of the house. DW2 Torun Sharma deposed in his examination in chief that he was an attesting witness of the registered gift deed of 126 dated 4/12/1998, and he knows that the offer and acceptance of the property of the gift deed. That executant Girish Chaudhary was fit and sound to execute the registered gift deed at the time of execution of the gift deed. Exhibit Q1 is his signature. In cross-examination, he stated that the deed was written by petition writer, as stated by Girish Chaudhary, and the gift deed was executed in the house of Girish Chaudhary. At that time, sub-registrar, a petition writer, Girish Chaudhary, Pobitra, and he were present. After execution of the deed, they drank tea and thereafter he went away. It is submitted by learned advocate of the plaintiff that the gift deed was executed without witness on 13/3/1998 and hence execution is not proved, and the deed was registered on 20/3/1998 and attestation of the gift deed is not proved. Further, it is submitted that the gifted property is an undivided property and gift on undivided property is invalid in law. Further, it is submitted that delivery of possession is essential in gift and the gift deed of the defendant is invalid as the possession of the gift land was not delivered to the defendant by defendant number 1. And in this respect, the learned advocate of the plaintiff has submitted the case law so and so. Further, the learned advocate of the plaintiff submitted that as the gift deed was not attested by at least 2 witnesses, so the gift deed executed by defendant number 1 is not valid. And in this respect, he submitted the case of law AIR 1975 Patna 140. From the cross-examination of DW1, it is seen that the case is running for the land of dag number 1017. So from the above, it is seen that the land of dag number 1017 is in possession of the plaintiff. From Exhibit Q, it is seen that nothing was written in Exhibit Q regarding delivery of possession of the land. Further, the cross-examination of DW2, it is seen that the deed was executed in the house of Girish Chaudhary, and after execution of the deed, they took tea and thereafter he went away. So DW2 stated nothing regarding delivery of possession of the gifted property. Further, PW1 and 2 stated in their evidence that the gift deed was executed on so and so. white deed number so and so, but from exhibit 4 and co, it is seen that the gift deed number 126 of 1998 was executed on 23/1998. From the cross-examination of DW2, it is seen that the gift deed was not attested by two witnesses, as DW2 clearly stated in his cross-examination. At the time of execution of the gift deed, he, along with the sub-registrar, petition writer, defendant number 1 and defendant number 2 were present. From exhibit 1 and 2, it is seen that the plaintiff 2, 3 and defendant number 1 pro forma defendant. Authorised Chaudhary are pattadars of patta number 57 of Patsala town, and plaintiff number 2 and 3 and defendant number 1 are pattadars of patta number 72 of Patsala town. It is decided by his lordship in AI 1971 HP page 5 that delivery of possession is essential to complete a gift under Hindu law. The defect of want of delivery of possession cannot be cured down by registration of the gift deed. It is seen that their lordships in so and so that the gift deed not attested by two witnesses is invalid. From the evidence and discussion, it is seen that the land of Dag number 1017, which was gifted by defendant number 1 to defendant number 2, is in possession of the plaintiff, and the defendant number 1 has not delivered possession of the gifted land to defendant number 2, and the gift deed was not attested by at least two attesting witnesses, for which the deed cannot be held as valid gift. Hence, it is decided that registered gift deed number so and so, dated so and so, is illegal, inoperative, and void in law. So, my lord, besides pondering upon the attestation part, the basic finding, as we understand, is that the trial court came to arrive at the finding that there was an amicable settlement, and from the cross-examination of the DWs, the admission came that this parcel of land under 1017 and the related DAL were in possession of the plaintiff. So it therefore stood established that properties which fell in my share were included in the gift deed, and over and above that, those discrepancies with the gift deed, eventually it was held that the gift deed is invalid, and hence decree for declaration and permanent injunction and confirmation of possession was granted. Now, this was challenged in the appeal, my lord. The appellate judgment, your lordship finds at page 10. I'm sorry, page 5. My lord, after the submission, issue number 5 was again taken up before issue number 4, my lord. The discussions begin from page 8, but mostly those are submissions from the respective councils, my lord. Now, if your lordship may straight away come to page 11, my lord. Page 11, the last paragraph, paragraph number 16, my lord. Page 11, my lord, para 16. Now, para 16, there is no dispute that the defendant number 1 had executed the gift deed in favor of defendant appellant number 2 with regard to the land which was inherited by him from his predecessor in interest, Kalpanath Debo Chaudhary, and the plaintiffs have challenged the said deed on the ground that the said same is invalid, as the defendant number 1 had no possession with regard to the said gifted property prior to its registration, and the defendant appellant number 2 cannot acquire right, title, and interest by virtue of the said so-called gift deed. But it appears that the gift deed was duly registered by the executing defendant number 1. As such, the same cannot be said as void and illegal, and the respondents plaintiffs cannot challenge the validity or illegality of the said instrument. Therefore, I find force in the submission of the learned counsel for the appellant. With the above observation, I beg to disagree with the decision of the learned trial judge when he decided this issue in the affirmative and against the appellant defendant. Accordingly, this issue is decided in favor of the appellant and against the respondent. Now, issue number 6 was thereafter taken up. This is the issue whether the plaintiffs are entitled for the decree of permanent injunction. Now, Manoj, if I may read this, because this also deals with the family settlement part of it. Issue number 6, it is an admitted position that the suit land covered by periodic patta number 57 and 72 of Patsala town, Bojali Moja, is an undivided land, and co-pattadars have acquired their land jointly, but that does not mean that such joint possession is sufficient to deprive the right of other co-pattadars, and such co-pattadars have no right to transfer his undisputed title. The plaintiff Dizendranath Chaudhary deposed as PW4, that his father Haranath Debo Chaudhary got 2 bighas 13 acres of land in Dag number 1017 and 1 bigha 1 kotha 18 acres of land from Dag number 1019 and 1 bigha 13 acres from Dag number 265, 266, 333 and 334. The witness also has deposed that the land covered by Dag number 1042 is mentioned in the gift deed, but the same is in possession of Horesar Chaudhary, and he is the owner of the said plot of land. Similarly, PW5, Horesar Debo Chaudhary deposed that the plot of land measuring 2 bigha 3 kota 6 lechas, covered by Dag number 1017, is in possession of the plaintiff since last 40 years, and he is in possession of the land measuring 1 bigha 1 kota 3 lechas of Dag number 1042 of the suit patta. After going through the evidence of the witnesses, it transpires that the plaintiffs have been possessing their respective plot of land by way of amicably settled in between the pattadars, and no formal partition was effected with regard to their respective shares in the suit patta. The evidence of the plaintiff has clearly shown that they have denied the right of the defendant number 1 with regard to the suit patta on the ground that they have been in possession of their respective plot of land since 40 years, and the defendant number 1 had no possession of any part of the land of the suit patta. But it is true that the defendant has right, title, and interest with regard to the share of the suit, since it is not partitioned, and he has every right to transfer his part or undisputed title of the suit patta in favor of the defendant number 2 as per the established principle of law laid down in section 44 of the TP Act. Section 44 is quoted, Manoj. Para 20, where the transferee of a share of the proviso is quoted thereafter, para 20. Then after that proviso, it is an established principle of law that the co-owner, co-pattadar cannot challenge the right of the other co-pattadar in connection with share of the concerned patta. The learned counsel for the appellant has submitted that no partition had effected in respect of the suit patta in between the pattadars of the original pattadar Kalpanath Debo Chaudhary. It has already been discussed in issue number 5 that the defendant number 1 had executed a gift deed in favor of the defendant appellant number 2 with regard to his undivided land of the suit patta, and the plaintiffs cannot challenge the validity of the said deed. And that does not mean that the defendant number 1 had no right or title over the land of the suit patta prior to execution of the gift deed. However, the admitted position is that the donor-donee cannot take possession of the exact position of their land without effecting a formal partition of their respective shares. In this regard, observation of the Honorable Apex Court in Ramdas versus Sitabai reported in so-and-so gives us worthy mentioning, wherein the Honorable Apex Court held that without there being physical formal partition of an undivided landed property, a co-sharer cannot put a vendee in possession, although a co-sharer may have a right to transfer his undivided share. Honorable Apex Court in so-and-so versus so-and-so reported in 1980, AIR 1966 SC 470 that now it is well settled the purchase of a co-partner's undivided interest in the joint property is not entitled to possession of what he had purchased. His only right is to sue for partition of the property and ask for allotment to him of which no partition might be found to fall to the share of the co-partner whose share he had purchased. It may be mentioned herein that the aforesaid findings and the conclusions were recorded by the Supreme Court by placing reliance upon an earlier judgment of this court in Siddheswar Mukherjee versus Bhubaneswar Prasad Narayan Singh and others reported in so-and-so, wherein this court held as under all that the vendee purchased at the execution sale was the undivided interest of the co-partner in the joint property. He did not acquire title to any defined share in the property and was not entitled to joint possession from the date of his purchase. He could work out his rights by a suit for partition, and his right to possession would date from the period when a specific allotment was made in his favor. In view of the aforesaid position, there could be no dispute with regard to the fact that an undivided share of a co-sharer may be a subject matter of sale, but the possession cannot be handed over to the vendee unless the property is partitioned by metes and bounds amicably and through mutual settlement. The Honorable Supreme Court in Gajra Vishnu Gosavi versus Prakash Nana Sashed Kamle and others held that thus in view of the above, the law emerges to the effect that in case an undivided share of a co-partner can be a subject matter of sale transfer, but possession cannot be handed over to vendee unless the property is partitioned by metes and bounds either by the decree of a court in a partition suit or by settlement among co-sharers. Now coming to the facts of the case is that the defendant number one, Girish Chaudhary, was a co-pattadar with regard to suit patta number 57 and 72. The contention of the plaintiff clearly shows that their predecessors and the defendant number one had been possessing the suit patta 57 and 72 and other plots of land which was inherited by them from their predecessor in interest Kalpana Debo Chaudhary by way of an amicable settlement. Thus, it transpires that the heirs of the original pattadar are also not aware about their possession or their exact area of land covered by patta number 57 and 72, and it cannot be ascertained as to which share of land would fall in their part after the effect of the formal partition of the suit patta. Therefore, I am of the view that being the joint pattadars of suit patta 57 and 72 of Patsala town, the plaintiffs cannot restrain the other pattadars of the same patta. Thus, I have sufficient reasons to come to a conclusion that the plaintiffs are not entitled to get permanent injunction to restrain the defendant from entering into the suit land till the effect of a formal partition. Therefore, I beg to disagree with the decision of the learned trial judge when he decided this issue in affirmative, and accordingly, this issue is decided in negative. Then comes issue number 4, Valor. In view of the discussion and decisions of the arrived in the foregoing issues, I am of the opinion that the plaintiff respondents alone cannot acquire any definite share or possession of the respective plot of land covered by the periodic patta number 57 and 72 unless the property is partitioned by metes and bounds in between the pattadars. The evidence of the plaintiff show that they have been in possession over the same. No doubt the suit patta originally stood in the name of the predecessor in interest of the plaintiffs and the defendant number one and other co-pattadars, and the same is in the position of unpartitioned, and the heirs of the pattadars have been possessing the land without effecting formal partition. This being the position of any of the pattadar of the suit patta have no right to challenge the right title and interest of the other co-pattadar till the effect of formal partition. There is no dispute that the plaintiffs and Horisar Devo Chaudhary are in possession of the land covered by Dag number 107, 1019 and 1941 of patta number 57 and land measuring 1 bigha 10 lechas of Dag number 265, 266, 333 and 334 of patta number 72 is in possession of Horisar Devo Chaudhary by amicable settlement. The exhibit 1 and 2 clearly show that defendant number 1 and plaintiffs and Horisar Devo Chaudhary are pattadas of the suit patta 57 and 72 of Patsala town. Therefore, it cannot be ascertained that only the plaintiffs and Horisar Devo Chaudhary have right title and interest with regard to the suit land covered by patta number 57 and 72. In view of the above, I am of the opinion that Horesar Debo Chaudhary and the defendant, number one, have right title and interest with regard to the land of Patta number 57 and 72 of the Pathala town. Accordingly, this issue is partially decided in favor of the plaintiff and pro forma defendant Horesar Debo Chaudhary. Then finally, the operative portion on the following page, my lord, issue number 7. In the light of the decision arrived at in the foregoing issues, I hereby hold that the plaintiffs are not entitled to a relief as prayed for. Therefore, I beg to disagree with the decision of the learned trial court when he decided this issue in favor of the plaintiff. Accordingly, this issue is answered in the negative order. In the result, appeal is allowed, filed by the appellant is allowed on contest, without cause. The judgment and decree passed by the learned trial judge or whether and so is accordingly satisfied. Insofar as the amicable partition is concerned, it was nobody's case that there has not been a partition. So perhaps that the court, first appellate court, should have presupposed the partition and then gone on to find out in whose share this particular parcel of land falls as per that settlement. Because even the plaintiff says and the defendant also says that yes, there has been an amicable division of the properties which were succeeded to by the three brothers. The question was not whether there has been a partition or not, but whether as per that partition, this land falls in the share of Girish Chaudhary or in the share of the plaintiff and the pro forma defendant. So therefore, that is, I would say, perversity number one, my lord. And secondly, my lord, we'll see the findings of the appellate judgment, my lord. In 2 or 3 places, my lord, it says it sort of tries to draw a distinction between an amicable settlement and a partition. So page 12, page 18, page 12 and page 15, your lordship will find contradictory observations. At one breath, it says that plaintiff and pro forma defendant are in possession of this particular suit land by virtue of an amicable settlement. But in the very next sentence, it says, but there has been no partition. Page number 12, para 18, the last portion. I'll just quickly read out those contradictory statements, contradictory according to me. Last but 6 lines, my lord, the sentence begins with after going through. After going through the evidence of the witnesses, it transpires that the plaintiffs have been possessing their respective plots of land by way of amicable settlement, amicably settled in between the pattadars, and no formal partition was effected with respect to the respective shares. So perhaps the notion is that a division by amicable settlement and a formal partition would be two different aspects, and so long as there is no formal partition, that amicable settlement would not give the status of a partition land between the parties concerned. But which is an agreement too. But going by where, I'll just get that judgment, that old judgment your lordship recalls Kale versus Deputy Commission. When there they said that in rural areas, that is how partitions can maybe take place by virtue of amicable settlement. So once it is amicably settled and parties are allotted respective plots, going by the language of the appellate judgment, then it must be held to be individual properties after that exercise is complete. Then again, if your lordship comes to page 15, right. Yes, that's right. That's right. That perhaps did not translate here, into the revenue record, but would that be sufficient to hold that there's still unity and jointness in the number page 15, again the last but 5 lines, last but 5 lines, so page 15, there is no dispute. Because it kind of draws. There is no dispute that the plaintiff and Horeswar Debo Chaudhary are in possession of the land covered by DAG number 1017, 1019, 1941 of Patta number 57 and land measuring 1 bigha 10 acres of DAG number 265, 266, 333, 334 of Patta number 72 is in possession of Horeswar Debo Chaudhary by amicable settlement. Yes. 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 Evidence are cited. In fact, I've gone through the evidence. The categoric questions were posed to the defendant's witnesses. And it says that this dispute is going on over the land where the plaintiffs are in possession, etc. So that is where the trial court appears to have drawn the inference that there has been an amicable settlement for sure, and this particular portion falls in the share of the plaintiff and the defendant. Well, and just to fall back on the other, now supposing if we go by that logic of the first appellate court that there may be an amicable settlement, we will still hold it to be a joint property, an unpartitioned joint property. There also, the learned first appellate court has relied on that very judgments of the Honorable Apex Court, which have said that what you can transfer is your joint interest, and it is for the vendee or the donee in this case to come forward and get the land partitioned so that he can take out his share. Now, if that be so, my lord, that is sufficient to decree my suit, because unless he comes forward for partitioning the estate and to get a defined share, my lord, I can injunct him from entering unless he partitions it. So there I find, there's another contradiction of sorts, in the sense that the First Appellate Court himself says it's joint property. Then it says you cannot have a defined share in this. But then again, discards my prayer for permanent injunction at least, my lord, where I say that he should not enter. So going by the reasonings of the first appellate court itself, my lord, I'm at least entitled to a declaration of title, maybe to the extent of my share, and then I should also be protected by way of an injunction so that he doesn't come before he actually gets the land partition. But again, having said that, I would that's just my fallback argument in the sense that since it is nobody's case that it is joint family property. So therefore, my lord, in the larger scheme of things, my lord, if at all it is held to be joint property, my lord, it is for the defendant number two to file a comprehensive. So now that then they'll have to also retract from their statement that the properties of partition, and then perhaps he has to file a wholesome partition suit where all properties have to be brought into the hotspot, my lord. And even if that is done, my lord, by virtue of the fact that I am still in possession, I can urge that if there should be limited disturbance. Because that's the rule of partition, if I've understood it correctly. So that finding is clearly contradictory with utmost respect, you know. Now, this is the judgment of the Supreme Court. So para 16 of that judgment, if you like to see. Para 16. And my specific case was on the strength of the gift deed, he now wants to enter into possession of that those specified portions. So hence the prayer for injunction. Then all the Wendy's would have popped up on it. Para 16. It is settled on that under the Transfer of Property Act 1882 that a purchaser cannot have a better title than what his vendor had. The possession which is claimed by the defendant number 3 Ramdas appellant herein in respect of the entire land bearing duct number 19 area so and so was also illegal and without proper sanction of law. So long as the property is joint and not partition, defendant number 3 Ramdas the appellant herein is not entitled to get possession of the land. Even otherwise, the appellant herein having purchased the land from the defendant number 1 Sudam could be entitled to be declared at the most to the extent of half share of the said piece of land, having stepped into the shoes of his vendor and could not have asked for and claimed ownership and possession over the entire land of gut number 19 ad measuring so and so. Without there being a physical formal partition of an undivided landed property, a co-sharer cannot put a vendee in possession, although such a co-sharer may have a right to transfer his undivided share. Reliance in this regard may be placed to a decision of this court in so-and-so versus so-and-so, wherein this court stated as follows. Now it is settled law that the purchaser of a co-parsoner's undivided interest in joint family property is not entitled to possession of what he had purchased. His only right is to sue for partition of the property and ask for allotment to him of that which on partition might be found to fall to the share of the co-partner whose share he had purchased. It may be mentioned that the aforesaid findings and conclusions were recorded by the Supreme Court by placing reliance upon an earlier judgment of this court in Siddhartha Mukherjee versus so and so, wherein this court held as under all that the vendee purchased at the execution sale was the undivided interest of the co-partners in the joint property. He did not acquire title to any defined share in the property and was not entitled to joint possession from the date of his purchase. He could not work out his rights, or he could work out his rights only by a suit for partition, and his right to possession would date from the period when a specific allotment is made in his favor. In view of the aforesaid position, there could be no dispute with regard to the fact that an undivided share of a co-sharer may be a subject matter of sale, but for the possession cannot be handed over to the vendee unless the property is partitioned by meets and bounds amicably through mutual settlement or by a decree of the court. So, taking the other view of things, which the First Appellate Court seems to have adopted, Manoj, even in such a circumstance, Manoj, at least my prayer for declaration and injunction would survive, and the adjustments, if any, required to be made on the basis of that gift deed would be worked out only in a suit for partition. Now, Manoj, the First Appellate Court, it did not really reverse the findings of the trial court insofar as amicable division is concerned. In fact, it endorsed that finding and said that yes, there is an amicable division, but it said that that cannot be equated with a partition. So once and well, if that finding remains, Manoj, then the gift deed would be encroaching upon my share. So, so that is one aspect which the appellate court did not take into consideration while deciding issue number 5. Because issue number 5, the appellate court merely said that you are not party to this, you do not even have a right to challenge, it's a registered instrument, so it will stand. I will draw your lordship's attention to that particular finding once again. Now, Manoj, that issue of family arrangement versus a real effective partition one, I just got this judgment, Manoj. Standard 9 perhaps B. Nineteen 1976, 3 SCC 119. Oh, I'll lordship will have. Para 9. This, your lordship will recollect, was partition deed and amicable settlement deed. But besides that, it also sort of focused to, yes, yes. The registration part also was very interesting. Para 9, Lord. Before dealing with the respective contentions put forward by the parties, we'd like to discuss in general the effect and value of family arrangements entered into between parties with a view to resolving disputes once for all. By virtue of a family settlement or arrangement, members of a family descending from a common ancestor or a near relation seek to sink their differences and disputes, settle and resolve their conflicting claims or disputed titles once for all in order to buy peace of mind and bring about complete harmony and goodwill in the family. The family arrangements are governed by a special equity peculiar to themselves and would be enforced if honestly made. In this connection, Kerr, in his valuable treatise Kerr on Fraud, at page 364, makes the following pertinent observation regarding the nature of a family arrangement, which may be extracted thus. The principles which apply to a case of ordinary compromise between strangers do not equally apply to the case of compromise in the nature of family arrangements. Family arrangements are governed by a special equity peculiar to themselves and will be enforced if honestly made, although they have not been meant as a compromise, but have proceeded from an error of all parties originating in mistake or ignorance of fact as to what their rights actually are, or of the points on which their rights actually depend. The object of the arrangement is to protect the family from long-drawn litigation on perpetual strife, which mar the unity and solidarity of the family and create hatred and bad blood between the various members of the family. Today, when we are striving to build up an egalitarian society and are trying for a complete reconstruction of the society to maintain and uphold the unity and homogeneity of the family, which ultimately results in the unification of the society and therefore of the entire country, is the prime need of the hour. A family arrangement by which the property is equitably divided between the various contenders so as to achieve an equal distribution of wealth instead of concentrating the same in the hands of a few is undoubtedly a milestone in the administration of social justice. That is why the term family has to be understood in a wider sense so as to include within its whole not only close relations or legal heirs, but even those persons who may have some sort of antecedent title or semblance of a claim, or even they have a successionist, so that further disputes are sealed forever and family, instead of fighting claims inter se and wasting time and money and energy on such fruitless or futile litigation, is able to devote its attention to more constructive work in the larger interest of the country. Courts have therefore leaned in favor of upholding family arrangement instead of disturbing the same on technical or trivial grounds. Where the court finds that the family arrangement suffers from a legal lacuna or a formal defect, the rule of estoppel is pressed into service and is applied to shut out the plea of a person who, being party to a family arrangement, seeks to unsettle a settled dispute and claims to revoke the family arrangement under which he has himself enjoyed some material benefit. The law in England on this point is almost the same. In Halsbury's Laws of England, volume number 17, third edition, the following apt observation regarding the essentials of a family settlement and the principles governing the existence of the same are made. A family arrangement is an agreement between the parties of the same family intended to be generally and reasonably for the benefit of the family, either by compromise, doubtful or disputed rights, or by preserving the family property or the peace and security of the family by avoiding litigation or by saving its honor. The agreement may be implied from a long course of dealings, but it is more usual to embody or to effectuate the agreement in a deed to which the term family arrangement is applied. Family arrangements are governed by principles which are not applicable to dealings with between strangers. The court, when deciding the rights of the parties under family arrangements or claims to upset such arrangement, considers that in the broadest view of the matter is the most for the interest of families and has regard to consideration which in dealing with the transactions between the persons, not the members of the same family, would not be taken into account. Matters which would be fatal to the validity of similar transactions between strangers are not objections to the binding effect of family arrangements. Now, my lord, binding effect is again emphasizing para 10. In other words, put the binding effect and the essentials of a family settlement in a concretized form. Yes, yes, yes. Within my house. Within my house. But he is his source of title is Girish Chaudhary, and if there is a family settlement before that, where Girish Chaudhary has been given some other parcel of land, so therefore, otherwise he is also family. Descendant two is also family. Well, Lord, in fact, there are overwhelming evidence on record where the witnesses were cross-examined. I do not like to trouble your lordship with the cross-examination, etc. PW5, Horisor Debo Chaudhary is also very clear. Then DW1, like I've already said, he admits that 1017 is in my possession. Then DW2 also says 72, Patta number 72 is, yes. Now first PW5, clearly says that the land which was gifted by Girish Chaudhary is in the possession of the plaintiffs and he has residential houses standing thereupon. DW1 says that the suit is pending in respect of the land where the plaintiffs are residing. This is DW1. He admits. They don't know. DW1 is defendant 2, my lord. So Dhoni says that. Then DW2 says, my lord, DW2 also says, Patta number 72 is where the houses are. Take it, take it. Citation is okay. Citation is only for the proposition that family settlement or formal partition, my lord, it has to be honored. And therefore, if there is a family settlement allocating this particular parcel to me, then the others will naturally, their rights would stand relinquished, my lord. So that is one. But I wanted to urge on the proviso to 44 also, but I'm not very sure because it says family, and he is otherwise family, though not part of the same family. Because if we interpret the word family, now this house is now the dwelling house in question is that of the plaintiffs, Manoj, and plaintiffs are own brothers. So far as defendant number 2 is concerned, madam, he is a first cousin. So whether the proviso to 44 would also apply. Now, if the cousin is considered family, of course not, Manoj, but ultimately, yes, defendant number 1. Proviso, Manoj, I'll not break. Respond to my friend, Manoj. So this is in some substance my argument, Manoj, that trial court findings insofar as amicable settlement, they were maintained, Manoj, but first appellate court sort of held that it may be family settled, Manoj, but it is not partition.
Yeah, Pedro. Also, you can see the copy of claims, Manoj. More particularly, page 38, Manoj. This is the case set out by the appellate, Manoj, in their claim. And more particularly, it starts from page 37. Page 37, where is paragraph 1. The 37 bigger two cut 3 lessons of plan, under the pattern of 57 of Pasala town, under Moja Bajali, subdivision Bajali, district of originally excluding the name of 3 brothers, namely Hemnath, Hemchandra, Devachiri, Kali, Kalpana Devachori, and Ramnath Devachori. Out of this land, Patada Hemchandra was entitled for 12 bigger two cut 8 lessons of land. Kalpanath was entitled for 12 bigger two cut 8 lessons of land. And Ramnath was entitled for 12 bigger two cut 7 lessons of land in the land. State Kalpanath Devachodri died, leaving his 3 sons, namely Giri Devachodri, the defendant number 1, Lakshmikanta Devachodri, Hornath Devachodri. The above 3 brothers equally divided their land in pattern number 57, and accordingly, each of the brothers were entitled for 4 acres and 16 acres of land. Patada Hornath was possessing 2 acres, 2 acres, 6 acres of land in Dag number 1017, including other land. The Patada Ramnath was in possession of 1 bigger, 1 cut 3 acres of land in Dag number 104, including other land. There was another plot of land. This is most vital in your lordship. There was another plot of land measuring 2 bigger, 1 cut 6 acres covered by pattern number 72 in the names of Giri Chaudhary, defendant number 1 here in India. Giri Chaudhary and let Hornath Chaudhary. During last settlement operation, the patta was issued in the names of defendant number 1 and plaintiff number 1 and 2. In the same patta, plaintiff were in exclusive possession by amicable settlement, and as such, defendant number 1 was never in possession of the land. After the death of Ramnath The land measuring 1 acres 2 covered by Act number 1042 is in possession of his son, Authorised Devachowdhury. Thus, defendant number 1 has no possession of our land of Act number 1042, 1017, and Pata number 72 of Patsla Town. Or this is the case set out by the plaintiff, my lord. The Pata is in my name also. In this Pata, my lord, I am half shareholder. This repeated record has not been partitioned by, separated by law. And out of my share existing in this Pata, I have encumbered my share only. Without subtracting the share of plaintiff number 1 and 2, my. Next, my lord. In this last sentence of this paragraph, my lord. In the said Pata, plaintiffs were in exclusive possession and by amicable settlement as a defendant number 1 was never in possession of the land. After death of Ramnath, the land measuring 1 acre 2 3 letters covered with Act number 1042 is in possession of his son Authorised Devachowdhury. Thus, defendant number 1 had no possession over land of Act number 1042, 1017, or Pata number 72. My lord, this is the say of the plaintiff that the land of Act number 1042, which I had encumbered by way of registered deed of gift, shown in Schedule A of plaintiff, my lord, page 40. According to the plaintiff, this land belongs to Authorised Devachowdhury. I have encumbered the same by way of deed of gift. But Authorised Devachowdhury has not joined his hands to the plaintiff to challenge the legality and validity of the gift. This is the only share of the plaintiff that I have encumbered the land following the share of the Authorised Devachowdhury also. But Authorised Devachowdhury has not come forward while challenging the legality and validity of the gift executed by me. Now, you also cannot see, in this case, in the plaintiff, my lord, this has been projected, there was amicable settlement. Either oral or in writing, fate is silent. Assuming for the sake of argument, there was amicable settlement, my lord, among the co-sharers. Where is my share? Fate is silent. They fail to disclose anywhere in the entire plain, my lord, that I have been possessing the land under Act number so Pata number so out of your family property. Well, whatever has been encumbered by the defendant number 1 in favor of defendant number 2 was only to the extent of his legitimate share by right of his intent. Before the learned High Court, plaintiffs have failed to place on record any document, my lord, that ancestral property was amicably settled amongst his all legal heirs separately, and they are enjoying their respective shares separately. Nothing is on record, my lord, before the trial. My lord, for the purpose of deciding this issue, my lord, legality and validity of the appellate judgment, I may be allowed to read the issue number 5. Issue number 5, according to the appellate court, my lord, at page 8 of the appellate judgment. Page 8, my lord, paragraph 9. Regarding finding of the appellate court below, my lord, in deciding issue number 5. There is no dispute that the predecessor in interest of the plaintiff, also therefore, and defendant number 1 are the joint parties of the suit pata, and defendant number 1 had executed leave deed number 22 in respect of the land in favor of appellant defendant number 2. Plaintiff Sri Kishore Chaudhary in his evidence, as Petitioner 1, has admitted that legal heirs of Kalpana Chaudhary, namely Giri Chaudhary, Lucky Chaudhary, Harana Chaudhary, got their shares, that is land measuring 4 bighas 16 lesser each out of total area of land measuring 12 bighas 2 kata 80 lesser in pata number 57. They have been enjoying their respective plots of land amicably. It is in his evidence that when defendant number 1, Giri Chaudhary, became mentally imbalanced, then he donated the land in favor of defendant number 2 in respect of his land measuring 2 bighas 2 kata 6 lesser and 1 bighas 1 kata 3 lesser of land covered by Dag number 1042, but the said land is in their possession along with his brother Dijendra Chaudhary since 1968. The other land of the said Dag number is in possession of the another Patadar Horace Chaudhary. PW4 Dijendra Chaudhary and another plaintiff of original 2 has supported the contention of PW2 regarding possession of the respective share of the land by right of inheritance by legal heirs of their predecessors, Kalpana Chaudhary. He deposed that legal heirs of Kalpana Chaudhary had amicably settled their land and had been possessing their respective shares as per said settlement, and each of them possessed land measuring 4 bighas 16 lesser in 2 patta, number 57. Pass on. We check the TC on.
Hello. Item number 6. Item number 6. Then another item number 22. Obligation.
Item number 11, review particular. Yes, yes. The urgency is there because the pendency of this case, DC could not be drawn.
May I please your lordship, my lord. Lordship, item number 12, lordship, that for an accommodation, lordship.
Item number 13.
Division bench item 1 with 2.
I have taken up the matter with the additional secretary of the department, and I have advised that for last 2 years, we are taking time on the matter, and the satisfaction actually by your lordship, I have conveyed. But the additional chief secretary, he has undertaken, that out of the rules and the policy, one will be notified within 1 month. And he has expressed that he is personally picking up the matter, and at the most, he is taking up within 1 month, one will be notified, and the other also, he is trying to do it, at the earliest possible it will be done. And he has personally conveyed, he has personally said to me, that personally he is taking up it with all the departments. Lordship, yes, yes. Lordship may record my conversation with the additional chief secretary. Lordship. Yes, yes. Yes. Yes, yes. Yes, yes. Lordship. 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 On 17th of July, Lordship has said.
17th of July.
17th of July, no,
21st.
21/7, Lordship. Madam.
Same thing.
7. Lordship.
This will be same day, but this is how we are writing.
Yes, yes. Lordship may record that as per the conversation with the additional chief secretary, Lordship may record that. Yes, yes. Yes, yes. Madam. Madam. Yes, 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 Fine. Additional Chief Secretary of the Women and Child Development Department, and the Member Secretary, Women and Child Development Department, and the Member Secretary of the State Child Protection Society. Women and Child Development Department, and Member Secretary, State Child Protection Society. Lots of questions.
Ultimately, it has to be placed before the cabinet and come into a reality, my lord.
Policy, yes, policy and the rules, both out of two, one, he said, within 4 weeks, it will be done. And the
Rule is important.
both, they are taking steps in respect of both. But he said that he cannot ensure both, but he ensures one. Lots. Otherwise, I have suggested
that we cannot blame the cabinet or anything. For the reason that it is not in that
Correct.
interdepartmental, I have said that interdepartmental, all the officers will be called. So, now, yes, yes.
Yes.
Yes. I have suggested that all the departmental secretaries or the officers should come to a meeting, and then and there it should be decided. I have suggested that.
You should take that suggestion.
Look,
We afforded tomorrow.
not, hold on.
Man,